Hello, my friends. Bradley J. and Jay talking, and we're with Michael Coyne, Dean of the Massachusetts School of Law. We do a session every month or so, 6 weeks. Call it Legal Roundup, Legal Briefing. Call it what you will. Maybe we should get an official name for it. Ladies and gentlemen, here he is, Dean Michael Coyne, Massachusetts School of Law. Hi.
Hi, Bradley. How are you today?
I'm all, feeling all optimistic about springtime and COVID numbers in Massachusetts anyway being diminished. So that's good. I see there's an award behind you, and I think there's a little bit of an interesting story behind that award. It's related to the Massachusetts School of Law, and another reason it's my favorite school of law.
Yeah, it is my favorite too, Bradley.
Show the people the award. It's cool.
It's just as you can see it. Can you see the stuff
on
it?
I can.
It is. We gave out some awards to folks around here who, over the last 2 years, have been stalwarts and really helped us get through a difficult couple years dealing with all the issues in COVID. As with anything else, some people will step up and some people get lost in the tumult of the times. And we had a number of people that really contributed above and beyond the call of duty to try and keep everything moving in the same direction. And I'm sure a lot of other folks had similar experiences at their work and what they were doing, working from home and contributing, because everyone had to adjust. And if you didn't adjust, the likelihood is you're still facing struggles. And we've been very, very fortunate here, both from the standpoint of health issues as well as success. So we're grateful to our colleagues and our employees and the folks that help to make everything work. And hopefully, as you suggested in the outset, that we've turned the corner and we're finally looking to put this in the rearview mirror. And let's hope we don't have to go through something like this ever again.
Is it a lot more pleasant over there? Is everybody kind of joyous and feeling free in the hallways, walking around school?
Yeah, no, we took masks off in February, the end of February, and with spring on the way and the warmer weather coming, I do think there's a little bit of a no pun intended, a spring in everyone's step, looking forward to hopefully resuming life as we knew it, being more careful probably. I'm sure everyone will be,
Right.
but we're ready. I'm sure everyone else is ready, and a little baseball, a little summertime on the common and down at the waterfront, and that'll be awful nice, won't it?
It sure will. Let's start off talking about the January 6th insurrection. It's been over a year now, and you see that over 750 people have been arrested in relation to that, and you start to see some court action. And I wanted to ask the status of some of the key cases. And I also have a first question, and that is, it seems to me that the people get undercharged. They could have charged them. They could have charged them with more serious crimes. It seems that there's a decision not to. I mean, some of these things are treasonous, maybe. I mean, trying to overthrow the government, sedition, but they seem to charge them with picky little things. Is that a conscious decision?
I think that is a conscious decision of this group of actors, is to not have long, drawn out, and far more difficult charges to prove. When we talk about treason, or, there are a number of officers ultimately died as a result of that activity. Could you argue that even manslaughter or murder should be on the table? And so I think what the government deliberately, and contrary to what it normally does, has in fact undercharged a lot of the individuals presently facing charges in an effort to try and speed the resolution of many of those cases through plea arrangements and the like. Very few at this point have opted to be tried and to really try to defend the charges. And that may well be in part, as you suggest, that these are relatively low-level offenses we're talking about months in jail instead of years for the most part, and that they would be relatively easy for the government to prove. What I do also think, though, is that there are much more serious charges that should be leveled, and frankly should have been leveled by now, against much more high people that are higher up on the food chain here. And that's where I think a lot of people question is why have we arrested and charged and jailed a lot of the soldiers that in the battle, as opposed to the people that organized it, the generals that led this, um, um, figuratively. And someone had to organize this and fund it to a much greater extent than we have evidence now. Congress is investigating it. But at some point, when all of the delays and the stalling tactics by various parties about turning over documents and the like, when that ends, then perhaps we'll have a real examination as to the people who funded and led the insurrection on January 6th, because I do believe that much more serious charges along the lines you've suggested would be appropriate for that group, because it was, as many see it, as I see it, an attack on our democracy, and a really dark time for our country.
Is it the case that if a person is charged with a lesser crime, the judge is more likely to insist on the maximum punishment in that lower crime than if it were a higher crime? They might give him the low end of what they could give him.
Yeah, that's not an unfair assessment of how a judge might look at this. Obviously, judges still look at, well, what would be an appropriate punishment based on what they've done. Now, clearly, they have to take into account the actual conviction and the charges that were brought. But when they look at the conduct, they can decide, and the person's remorse and their prior history and all the rest, they can decide what's appropriate. But the conduct that they engaged in would actually be, regardless of the charge, something that the court would look at. And, for a lot of these cases, minimum sentence might be 6 months, and the maximum, if it's not a felony, is only a year or so. Well, the court might well be inclined to still sentence to the longer period of the year,
Right.
simply because of how egregious the conduct was. So I think that's a fair way to look at it. When the range is narrower, isn't it more likely that the court will look at the more severe part of the sentencing guidelines? And that's not an unfair way to look at it, that many judges would look at it that way.
So a judge can, to himself or herself, say, wow, they could have charged this guy with a lot more. I'm inclined to, since this is a lesser charge, go to the top of the range.
Yes, because they're trying to punish the conduct. And part of the sentencing is to appropriately punish the conduct that they were engaged in. So even if, there might have been other charges, higher charges with a longer sentence that the person could have been charged with, the court still has to appropriately punish the conduct itself. But remember, in federal court, there are sentencing guidelines that do narrow the judge's range of potential sentences and looks at a whole host of factors. But one of the factors is going to be the actual conduct engaged in, the effect it had, the harm that occurred as a result of it. And as we started down this road, for a lot of these offenses, the harm was quite significant. The danger was even greater, and that we did actually have loss of life that was attributed in part to the mob's actions that day. And so when you think of it in that way, well, then, a sentence of only a month hardly suffices for conduct that had such horrible consequences.
Okay, we have Gary Wesley Reffitt. He's facing 60 years in prison. I have a journalistic question in here that I'll get to after.
Okay.
You'll see. A Texas man accused of allegedly bringing a semi-automatic pistol into the January 6th attack on the Capitol. Is that redundant? Isn't an accusation an allegation already? Or do you have to say allegedly, even if you say accused?
No, I think yes. I think that's redundant. If it's only an allegation, you don't and at that point, all charges in essence are allegations by the government. until we get to trial and actually at trial or we get a plea, these are what the facts are alleged to be, but we need evidence that supports it. I don't think we have to be redundant and say allegedly he's done this or that. If you're saying he's been accused of or charged with carrying a gun into the Capitol.
I just want to do it right, cover my own button. You see, journalists always say allegedly, no matter what. Now, what if the person is found guilty in a court of law? At that point, do you still have to say allegedly, or is it a fact at that point?
No, then it's been established and there's a judgment to that effect. And no, you don't have to say allegedly anymore. The concern, obviously, about using language that is cautious is that accusing someone or saying someone has committed a crime if they have not, that's what we call per se libelous. You've said someone committed a crime, but they didn't. They haven't been proved to have committed the crime, and so they can argue that you've libeled them through the use of such expression in the newspaper or here online and wherever. And that's what the concern is, that I think a lot of the media is taught to be cautious in that regard because of the potential penalties for defamation.
Isn't the burden of proof on them to prove they did not do something you said they did?
Like no. What did I understand that correctly? If I say you did something, then the burden is on me to prove you did something. It's not, the burden shouldn't be on you to say prove that you didn't do it, to prove the negative.
Okay.
If I say Bradley's wearing a hat, I've got to prove Bradley's. I should have to be the one to prove Bradley's wearing a hat, not you to show you're not.
Okay.
If I understood what the question.
That was the question.
Okay.
It seems like just a kind of an arbitrary choice. It's like, why is that? Why is that? How'd they decide that? Well, what if I genuinely feel someone committed a crime and I'm saying, hey, you committed a crime? You have to prove you didn't.
But see, that's my problem with a lot of today. What is the assumption that what you feel in and of itself is good enough instead of being confined to facts? And I think that's what's led in part to how polarized we all are, is that your feelings are more important than the actual facts. Well, they're not. Right?
Okay.
We should operate on the basis of what the facts are, not what you might think they should be.
All right. Well, thank you for taking me to school on that.
No, I don't mean to take you to school. I do think, don't you think in part?
Yeah, you're right.
We've traveled so far down this road. You know, I had a conversation with someone last week and says, well, he said, no, that's my feelings and that's a fact. Well, no, those are two different things sometimes. I understand why you feel like you do, but that doesn't make it a fact.
Right. Okay, back to this guy Wesley Reffitt. He allegedly, besides bringing the gun, told his kids allegedly that traitors get shot. Is that is that a crime? Is that potentially interfering with a witness?
It's poisonous conduct is what it is to the jury. And that's, at least in part, why he probably got convicted. You know, and that really was some of the headlines about it, that his son had to didn't have to, but testified against his own father with respect to his participation in the January 6th riot, and threatened his children if they were to cooperate with the government about it. You know, the fact is, based on the information that was brought out during the trial, is not only did he show little remorse, but the threatening, the conduct post, the cover-up, the conduct against members of his own family, even if it's not criminal, shows that the lack of remorse, the lack of sort of respect for cultural norms and the like, and I think as a result of this, he likely is going to be severely punished when it comes to ultimately the sentence and what he has to serve as a result of it. May not be, I mean, you know, the the threats to witnesses is in fact a separate crime. The problem is it's much more egregious as we look at it here in our hearts. And I think that's going to cost him more significantly when it comes to sentencing as well. Plus, think about the destruction of the family dynamic there, and when children have to testify against their own parents, it's just horrible.
He gets sentenced in June, faces a maximum of 60. What's your educated guess he'd get? 15? That's quite a lot, really.
Yeah, I haven't looked at the sentencing guidelines, but I still think it'll be less than that. None of these folks have been sentenced for extended periods of time. Either, federal system uses months as opposed to years. I could see where he could get 4 years in jail, 48 months, something along those lines. But again, it's another thing when you talk about the charges that have not been as significant. Is the gun more significant than the bear spray that was used on the police officers and to breach the Capitol to begin with? Is it worse than using a flagpole as a weapon? I mean, obviously, to some extent, it shows a greater intent, but there's a lot of weapons and things that were brought there that shows that similar level of intent as well. And a lot of folks, part of it was they believe the right to bear arms, and even if when their government is misdirected or needs to be, their activities need to be curtailed. My guess is unfortunately there were a number of firearms there on January 6th and other potentially deadly weapons as well.
And when I see the guy beating the other person with a flagpole, that looks like he's trying to kill that person to me. I don't see why that's not attempted murder. I don't see why, if you break into the Capitol saying if in fact I vaguely remember somebody saying we're gonna hang some people.
Yeah.
Why isn't that attempted murder? I'm broken in and I've stated my intent.
Well, for attempt crimes, you have to generally get what we call dangerously close to completion. So it's not just that you desire it and that you have the intent, but if you want to show that someone is guilty of an attempt crime, they have to be relatively close to completion, not just having spoken about it. And so that's the question is, how close were they to Pelosi? How close were they to Pence to actually carrying out what some say was the stated goal that day? And while we're on that part of it, there are suggestions that Congress people through Twitter and the like were providing information as to where Pelosi was, where Pence was. And again, to me, this is what I find very troubling is we're looking at all these low-level people who really, I could see, as misdirected as they were acting in accordance with the commander-in-chief's directives, right? Remember the rally is, come on, we're going to march on the Capitol and I'll be right there with you. And then of course, he's nowhere to be found as they're all marching to the Capitol, and there's horrendous danger and injuries that are in the Capitol as they breach it. I do think that there's a gross inequity when we've got perhaps Congress people involved. We need their emails. We need that information when the members of the administration are involved, and no one has faced such serious charges or scrutiny as to their activity. Now, I know people are going to say, well, Congress has been investigating it. But, if this was a crime in Dorchester or Roxbury or up here in Lawrence or Andover, we would have had an investigation and charges by now. And the fact that it's powerful and influential people shouldn't mean that at some point they don't face justice just like the rest of us would.
Phil from up in Keene, New Hampshire asks, what's the degree of probability the former president will be charged?
Based on the information that I've seen, and I don't have access to the information Congress has or others, but there certainly appears in my mind to be enough information on the record as we presently have it that whether it's inciting a riot, whether there are other related type charges that don't go to the level of treason, that and the funding of this, there does appear to be a concerted effort to fund this entire enterprise through associates of the president and the administration. To me, that there should be some charges that could withstand the challenge of both the First Amendment, the right to speak, as well, and especially political speech is strongly protected. To me, I think the president could be charged. The question is the will of the present administration and the attorney general, whether they desire to. If I had to guess, I am not sure the president will be charged, but I could see some high-level subordinates, even family members and significant donors charged with some offenses relative to the rally and the incitement on January 6th.
All right. And by the way, another comment from Phil. Dean Coyne, nicely matched his tie and shirt.
It's St. Patrick's Day.
And right. And I have to agree. It does look, it really pops. With the other chargees, you have a person who is the chairman of the Proud Boys, allegedly joining with other leaders to discuss a plan to attack the U.S. Capitol. Now, that adds a further layer of culpability in that it conspiracizes it.
Oh, yes, but I don't think there's any doubt that there are a number of individuals who conspired and made this a concerted effort to attack the Capitol and to attack our democracy and our election on that date. And I think you'd have to be living in a cave to not agree with that. The question would be, well, it just like the Tea Party and the like, if our government has become so misdirected and off the rails, isn't the as an American, don't we have the right to reject that tyranny? So I'm not so sure people would disagree that there was a concerted effort on January 6th. I think what people would disagree about is, was it justified under the circumstances, and especially considering our history and our acts against tyranny in the past, isn't it consistent with being an American? I think that's, to me, more the defense that I hear. I think the problem is that's not likely to be a successful defense. But right. I do think that
because there was no tyranny, there was adherence to the law, the election law.
Well, that's the thing, is that to try and overthrow the U.S. election for president, and again, Phil asked earlier about the president's involvement in this. This was done at his request, at his urging, and it was done because, as he tried to perpetrate it, it was a fraud. The election was a fraud. So there is involvement all the way up. The old expression, if you fill something with gasoline and spark a match, well, you're responsible for the fire that ensues. And that,
right, you have a reasonable expectation.
I don't know how you couldn't have had a reasonable expectation when you stir people into a fever pitch and then send them on their way. And even members of his own party were gravely concerned about the vice president's safety, about the safety of the Capitol, about their own safety, because many of them were in the chambers and the like. So, I mean, it was, that's another part I think that's troubling, is on that day, that evening, we were Americans again. Even our politicians looked beyond party lines and criticized it for what it was. Unfortunately, days, weeks later, we're now bitterly divided, and somehow it wasn't as bad as our own eyes showed us it was, and as ultimately the deaths that followed from the Capitol Police officers and the like. Most of us saw what took place and made our own assessment. It's too bad the politicians can't put politics aside and really agree that should be addressed.
We're with Dean Michael Coyne, Dean of the Massachusetts School of Law and longtime colleague, pal, guests. Next, we head to the Ukraine conflict and the fact the International Court of Justice ordered Russia on Wednesday to stop the actions it started on February 24. The Russian Federation shall immediately suspend military operations. What kind of teeth does this court have? From where does it derive its authority? And what kind of enforcement is available to them?
There's really no enforcement vehicle that is going to help the people of the Ukraine in the near term. The fact is, when you first said, can we talk about war crimes and the like for Ukraine? As always, you're a little ahead of it, because even yesterday they were talking about war crimes in the speech to Congress and the like, and in fact, the challenge on war crimes has already been filed with respect to Russia's actions in the Ukraine. The problem is the teeth that it has is limited. And we also get into ultimately the sort of the nuts and bolts question of, well, what's a war crime? Who can prosecute it? And, how do you stop it? Almost universally, these are after the fact charges, simply because ultimately the winner of the battles, the war, usually is the one that then ultimately tries to bring war crimes charges against the other. It's not always the case, but the fact is that there are a number of deaths during war. There's a lot of expected collateral damage. But when we talk about war crimes and we talk about the Ukraine now and the images we've been seeing, well, a lot of these targets, a lot of the buildings that we've seen are residential facilities. I think either last week or within the last week or so, I saw a hospital bombed. The fact is that the targeting of civilians or civilian places like hospitals and the like, by all accounts, is going to likely violate the Hague and the Geneva Convention, and that's sort of in the Rome statute that really are the basics for what would constitute war crimes. It's got to be over and above what you generally expect and what are cultural norms. But the question is, aren't we seeing that now, at least in part, in Russia's both invasion of the Ukraine for what appears to be a difficult reason to justify, as well as now the numerous killing of the civilians and the like. And so that becomes the question is, well, so what can be done about it right now? We have the United Nations to look to. We have a couple of international courts, International Court of Justice. We also have an International Criminal Court. But in the near term, the fact is that they're not likely to be very effective. Some of the stuff from Bosnia is still pending,
right,
at the International Criminal Court.
I do have an idea, though. Here's an idea of something that could be done immediately. Germany, as last I knew, Germany was still getting Russian oil, and it could make a rule among nations that adhere to the World Court that, look, as soon as this guy is deemed a war criminal, it's illegal for any of you nations to do any business at all, and that would really have some immediate effect.
I don't disagree. I think the sanctions are likely having some effect now. I think the cutting off Russia from the International Monetary Exchange is having an effect. The problem is we have a dictator with a hard focus on returning Russia to the days of the USSR and some would argue the colonization of Europe here.
Yep. there's no real answer to this. It's just my observation is, gee whiz, I can't imagine that whatever you hope to gain is worth what you're giving up, because it's going to cost you big time. I mean, you want to, do you want a buffer? You want Ukraine to be a buffer between you and NATO? That's a pretty high price to pay. Are you just trying to wipe out the Ukrainian culture? Even, that's you're paying a big price for that. One more thing on this, and that is, soldiers seem to be forgiven for the crimes they commit if they're ordered to do it. But I'm not comfortable with that. I mean, if you're ordered to go and kill a bunch of children, for example, or dig a ditch in Srebrenica and kill 8,000 men and boys, and your bosses tell you to do that, your command, shouldn't you kind of be on the hook for doing that, even though you're ordered to do it? I mean, maybe it's just too difficult to prosecute a million people who were soldiers. I don't know. Is it just a matter of the logistics of it, or is there some larger principle at work?
Well, it raises a great question, because a general matter for war crimes that have to be grave abuses of the conventions and the cultural norms of war. So it's not just that people are killed accidentally, or that you mistaken a civilian for a member of the other side's army. You've got to be well outside the norm. But once we're well outside the norm and it's a war crime, the fact that you were following orders is of no defense. If you remember, I mean, there's a couple of stark examples of this. The classic one is the Nuremberg trials, where a lot of the soldiers and generals were saying, well, we were just carrying out orders, which we know that there were orders to that effect. But the standard became that is not a sufficient basis for the commission of a war crime, and you can't, and that defense is going to be unsuccessful. Now, Nuremberg was World War II. But if we go and look at the My Lai massacre from Vietnam, what we're going to find is that even though an incredible amount of civilians were killed during that, the only person that was ultimately convicted by way of court-martial with respect to those charges was Lieutenant Calley. His supervisor, who by all accounts provided the orders that were the basis for Calley's and others' actions, his supervisor, Medina, was cleared of any charges with respect to the war crimes committed against the My Lai civilians. So as a practical matter, your point is well taken. Soldiers are not required to follow illegal orders, shouldn't follow illegal orders, but oftentimes that becomes an item in the defense, even though as a legal matter, carrying out orders from a higher up is not a sufficient basis for relief from any criminal charges.
Wayne Greenside points out something kind of legitimate, but I don't have the time to delve into this under the definition that we've kind of been working with, that dropping an A-bomb on Hiroshima could be argued as a war crime. I guess that's right.
Well,
I guess you might have a point.
I don't disagree with that. What's
but
interesting,
it might still have been the right thing to do. How about that?
Well, but and again, that's part of the whole where we started, and where we started with respect to the Romans and the Greeks was that if you won the war, whatever you did was okay because you were the victor. To the victor go the spoils. We've come a long way from there, but the fact is we want to charge the Japanese with the bombing of Pearl Harbor because we were not enemy combatants at the time. We were at peace with Japan, and nonetheless, they bombed Pearl Harbor with a horrific loss of life and the various casualties there. But then not shortly, but thereafter, we bombed Hiroshima. And the question is, well, there were obviously civilian lives lost there. Were they targeted? But if you look at the Hague, the Geneva, and Rome, the actual norms set with respect to what's fair in war and what isn't fair, the targeting of civilian areas, the willful targeting of civilian areas, is in fact generally considered a war crime, as one would expect, I think, because they are not enemy combatants. You're deciding that for tactical advantage, that this will be something we can carry out successfully. Well, the same could be argued about hospitals, about prisoner of war camps. The same point could be argued, but if they're targeted, that would fall within generally accepted definitions of war crimes.
Yeah, if we'd lost World War II, then it probably would have been a war crime, but we won.
Right. Well, and Bradley, that is what a lot of the cases and a lot of the information says. It depends on who wins as to whether it's classified ultimately as a war crime or not, because generally these prosecutions are carried out by the winners, and the losers have to suffer that as part of the fate as well.
Right. And history is written by the victor.
Again, that's true.
Okay. And well, the time is going quickly. One more topic, and that is we revisit the notion that it's never a good idea to talk to the police ever. I sent you, by the way, maybe a year ago, a video where an attorney and then I think a police officer both took a half an hour to explain all the ways where it's really bad to speak to the police without a lawyer present. But there's a situation where you get pulled over and there's got to be some gray area there. Do you just not talk to the police when you get pulled over? What do you say? I can see, of course, if they bring you in there and accuse you, did you do this? Where were you? Okay, I'm not saying anything. But what about when you just get pulled over? Would that make things worse for you, or should you still not talk to the police?
And I know that this is difficult for most people. I have a lot of friends in law enforcement, and we want to be cooperative as people generally, especially with parents with kids. This becomes a significant issue about respect for authority and all of that. But as a general matter, talking to the police is not going to be beneficial. And oftentimes, just as they tell you and you hear on TV, what you say can and will be used against you in a court of law. So for the most part, no, you shouldn't talk, and you certainly shouldn't talk without a lawyer. But so what do you do when you're pulled over?
You're alone out there on 128.
You have an obligation to identify yourself. You're going to need to provide your license. But a lot of criminal defense lawyers say, that's it. Roll the window down a little bit, or I guess now push your button a little bit, hand your license out. And oftentimes, you don't want to say anything necessarily other than identifying yourself, because then, well, I smelled an odor of alcohol when he said X, Y, or Z, or the speech was slurred. So the problem becomes anything you say can and will be used against you.
Even the way you say it, not even necessarily the content.
Even the way you say it will be used against you.
Wow.
And so that becomes the problem. I always tell my students, and I think I've told your listeners before when we talked about this, we had a conversation around our dinner table one time about a problem someone else had in the neighborhood. And my wife said to one of my children, well, listen, if the police came here and they asked to search your room, I trust you. I would let them go up and search your room. I trust you. And they said, well, you shouldn't. And they meant both. Don't trust me. I'm a kid. I don't necessarily do the right thing, and do not let them go to my room. The point is that we want to cooperate as individuals. We want to cooperate. We want to teach our children respect and cooperation. But the point generally is, and I know this sounds terrible, but nothing good generally is going to come from your cooperation with law enforcement if, in fact, you have participated in some likely illegal activities.
All right.
That's going to be used against you.
So let's all do this. I don't know if this, I'm going to do a pre-enactment. Is that a thing? Did I just invent a thing? A pre-enactment. Okay. This could happen. Say I'm driving up to New Hampshire on Route 93. and I'm going, I don't have cruise control on. I'm paying attention, but your foot gets a little heavy. You don't realize you have a nice car. Whoa! All of a sudden, boom! There's a trooper parked in the middle there. You realize you're going 15 miles over the speed limit. That's never happened to me, but it could. And you see him pull out. You think, oh no, no, no! He pulls. The lights go on. He pulls you over, and he comes up behind the car. He touches the taillight to put his fingerprint on it in case anything happens. And I should wait before I do anything. Like if he says, get license registration, then get it out, or should I get it out beforehand? Because I fear that if you get out beforehand, he might perceive that you were getting a gun.
Yeah, here's the problem in this regard, and I've talked to my friends in law enforcement about this. You don't want to be, and my registration is over in my glove compartment, so I'm going to have to reach, and you can see that. My license is in my wallet, so I'm going to be going like this. And so from law enforcement standpoint, they want your hands at 10 and 2, and they'd like the light on in the car so that they can see. That's what my instructions have been in the past. Now, here's the problem with that, because so then I don't have my license or my registration available, but then when they come, I can get that. But I don't want to have a conversation. So you should have a little piece of paper like this in the car, and you can say, I don't want to talk. Here is my reg and license, and not talk because of what
This is great.
And so have the window down a little bit and just hand the license and registration out. So you want to have a little pad of paper so you can do this. And especially if it's later in the evening, you've been out, you've had some cocktails. The fact is it isn't necessarily beneficial to have that exchange. I can't tell you how many police reports say when I talked to him, I noticed glassy eyes, slurred speech, and a strong odor of alcohol emanating from their breath. I think law enforcement hits a button and that goes into police reports for DUIs. And so you want to be careful in that regard, but you want to be careful generally. Again, I'll use the parent and the children explanation because I've represented kids. I've represented kids before, is that a lot of times law enforcement will say, well, listen, can you just have him come in and we'll talk to him. Hopefully we'll be able to resolve this without any issues. And here's the problem, is that whatever the child or the juvenile says, now they've got counsel or their parent present, even though the parent wants to sort of do the right thing, that stuff is likely going to be used against the child. So even when it's something what sounds like innocuous, kids drinking alcohol at a party or someone buying the alcohol and then them having it together. I can't tell you how many examples. We saw this situation out in Dedham recently that's still playing out. The fact is that these can have serious consequences for that child. And once the police once law enforcement knows that a crime or feels likely that a crime has been committed, they don't have the leeway that people necessarily think they do to not charge or to not go forward. That's where the problem comes in, is now now that they're aware, they have evidence that a crime has been committed from the person's own mouth. It's very difficult to not pursue charges. Perhaps they'll be more lenient on the result, but you're still facing criminal charges. You're going to have to hire a lawyer, and you're going to have to then go through with the court process and likely some resolution of it. It gets to be both an expensive and time-consuming venture, and it also can affect that child's future. Separate out parental discipline issues or our own internal family discipline issues from involvement with law enforcement.
Dean Coyne, you're the best. We're at the 45-minute mark, so I'm going to call it a day. I don't want to.
Sounds good to me.
I want to save something for next time. Michael Coyne, Dean of the Massachusetts School of Law, and just a great guest. A lot of great information. Thanks very much.
Thanks, Bradley. Great seeing you again.
Okay, we'll be
Thanks.
clear.